gone into the legal currency of India. There is two types of contempt in this act mentioned, an improvement over why this contempt of earlier there is no this kind of act, but there is a two types of earlier also this kind of acts is there in 1926 and in the year 1952 there is some act of the contempt of court, but again developed not exactly the contempt of the court, but these in the year 1971 they have focused on especially for the contempt of court in two ways. There is a civil contempt and criminal contempt. What is civil contempt? Civil contempt means willful disobedience to any judgment, decree, direction, order, writ, or other process of a court, or willful breach of an undertaking given to court. The term willful breach of an undertaking given to a court. The term willful is important in this definition. So there is no contempt if the person who has violated the order no knowledge of it. Right? This is the one important point you must be aware. So what will become in the criminal contempt? Criminal contempt means the publication. This is applies to the journalist. This is applies to the media. Criminal contempt means the publication, whether by words spoken or written, or by signs, or by visual representation, or otherwise. All these are the publication. Publication means not only the print media, here will come some electronic media also. Visual representation in this text which you are watching on the slide, that means a photograph. But even though electronic media, new media, and there is a new media, for new media there is another act will apply, but electronic media also comes under electronic media, whatever the media will come under the criminal contempt in case if any matter or the doing of any other act whatsoever which, number one, scandalize or tends or scandalize or lowers or tends to lower the authority of any court. We should not be right. Means while reporting, we should not be give any low, means lower the status of the court. Next, prejudices or interferes or tends to interfere with the due course of any judicial proceedings. For example, if there is a judicial process is ongoing, we should not give in our newspaper what will be the final verdict. So that will attract the criminal contempt of court. Another one is interferes or tends or interfere with or obstructs or tends to obstruct the administration of justice in any other manner. So criminal contempt comprises three species of conduct vice versa the court. Now, next, there are certain defenses. So what is breaches, you know, we know now already. But sometimes there is we can also protect us. So there is some defense also is there in the code. There are certain defenses provided under the code, under the act. They are: number one, innocent publication and distribution of matter is not contempt. See, one verdict is already released, given. When you can write as it is, but not don't change. If you write it, it will be not attract the contempt of court. Number two, fair and accurate report of judicial proceedings is not contempt. In case the judicial officers themselves, they given some matter to you to publish in the newspaper or broadcast in the television or radio, then it will not comes under the contempt. So because they are only given the accurate report, their authority, they are given with their authority. Number three, fair criticism of a judicial act is not contempt. What do you mean by fair? So we should not be involved the verdict, but we may suggest, not the verdict suggestion, the process, even the process also not, but the process is only we have to view the what is happened in the court, what is pending. So just that is a fair criticism is also not attract the contempt of court. Truth of the statement is not also is also one defense. If there is a truth, we can if we are means not in the judicial process, not in the procedure of courts, but in case it is truth, we may express it. But that truth should not be affect the verdict. Next, the interlinkage with the criminal contempt and the press. What will be happens? As far as the press is concerned, it is a more involved in the criminal contempt of court rather than civil contempt. Most of the newspaper cases involve the charges of scandalizing court. As mentioned earlier, criminal contempt means scandalize lawyers or lower the authority of any court. Next, prejudice, interferes of any judicial proceedings, interferes or tending to interfere in the administration of justice in any other form. So these are comes under the mainly these kind of points, these kinds of cases involved in the press. So be cautious while covering the judicial beat. The reporter generally newspaper organizations, they recruit the reporter, means a beat reporter or staff reporter who was assigned by the editor about the court, the legal news. So many times they adopt a legal study, legal person only, means either he has studied a law course, because they know many sections and how to be defend, how to be write in the newspaper without any attraction of contempt of court. Even though without a legal knowledge, means legal education, legal graduation, as a reporter, we must be aware about the contempt of court. There is many other points. For some cases also case studies also we have mentioned in the textbook, like Bharata Kantanishta versus Chief Justice, one case in the Supreme Court, and another case Tyagi versus Gupta in the year 1974. One more Bharata Kanta versus Registrar, means judicial officer. Yeah, registrar means not another other kind of a register, judicial department register. And some more cases, perspective publications versus state of Maharashtra. These are some cases we have given in the textbook. Once you go with, once you read it, so what will be the wrong here in these cases? Once just I will revision it. So here personal wrong against him or her and becomes an injury to the public if it tends to create an apprehension in the minds of the people regarding the integrity, ability, or fairness of the judge. Another one is tends or deter actual or prospective litigants of the people regarding the integrity, ability, or fairness of the judge. From the placing complete reliance upon the court's administration of justice. And another cause, embarrassment in the minds of the judge in the discharge of his otherwise her judicial duties. Once the writing held as a contempt, it is immaterial whether the dilatory criticism of a judge relates to his functions as a judge. In a judicial capacity, as is held in the case of Bharata Kanta versus Registrar in the year 1974, in a purely administrative capacity, in even non-adjudicatory matters. There is a forums also, forums of scandalization. Alleging that a judge influenced another member of the bench to be committed to his view, so as to interfere with their impartiality. The one judge told the line of other, as is found in the cases of Dapatri versus Gupta in the year 1971, and CF Advertisement General versus Bharata Kanta in the year 1974. These are some cases. Writing a letter to the judge imputing prejudice, malice, and dishonesty, making such aspersions in a notice to sue him or his judicial act. This is in the case of Advocate General versus Subbarao in the 1976 year. And there is more cases. Just as a journalism student, you once Google it in the network, you will get more cases related to the contempt of court versus press. Here, one more clause you have to know. It is clause 2C of the Act. What is mentioned in this clause? He judices or interferes or tends to interfere with the due course of any judicial proceedings. It may take many forms, but the test in each case is whether the act or writing complaint of a tends the fair hearing of the proceedings. Example, by deterring persons to come forward as a witness, causing parties to discontinue or compromise the proceedings. Here, the prejudice again in this context means to obtain a result of a legal proceedings different from that which would follow in the ordinary courses. Expectation or defense is only innocent publication. A journalist has therefore to be very careful before publishing speeches made by high dignitaries. If he or she has a reason to believe that there was a matter pending before a court in regard to the subject matter of such speech. See, we see in the YouTube channels and some electronic media and even though in the print media, many persons, if we ask any questions as a journalist, they says the matter is in the judiciary. So they don't say about that one. Because if there is a matter is proceedings in the courts, even though politicians, even though persons, means higher authorities or dignitaries, they don't speak about that matter. In case, as a journalism student, as a journalist, you don't be interfere. Already, interfere with the things of other judicial proceedings. It will be attract the contempt of court. It is important to note that the intention of the alleged contemner is immaterial. What is relevant is its probable effect on the judges, parties, witness, etc. in relation to pending proceedings and not its actual effect. Further, truth of the facts is no defense if the statement is likely to prejudice or interfere with the due course of justice. So these 2 points must be keep it in your mind while reporting legal news. Okay, my dear students. Dear students, if you have any doubts, please raise your hand. Otherwise, you may type in the chat box. I will read it and get you back with the clarifications. If you have no doubts, I will go with the next topic. That is the Indecent Representation of Women Prohibition Act in the year 1986. The Indecent Representation of Women Prohibition Act, year 1986, administered by the Department of Women and Child Development, Ministry of Human Resources Department. This act provides for the regulation of representation of women in media. It is an act to prohibit indecent representation of women through advertisements or in publications, writings, paintings, figures, or in any other manner. And for the matters contacted therewith are incidental thereto. Prohibition of advertisements containing indecent representation of women, prohibition of publication or sending by post of books, pamphlets, etc. This containing indecent representation of women. So these are the some causes of indecency. So what will be happens? Section 4 of this act, the Indecent Representation of Women's Act. The section 4 prohibits the production, sale, hire, distribution, circulation, sending by post any book, pamphlet, slide, film, writing, drawing, painting, etc., which contains indecent representation of women in any form. There is a exemption. Exempts films from this provision as the provision of Part 2 of Cinematography Act 1952. This applies to the films. Except the film means what we see in the cinemas. Remaining all will come under this act. For films, there is a films means present day movies which are placed in the theaters or OTTs, whatever there is. There is a OTTs, that is a different act. For films, movies, whatever it is, which are placed in the theaters or television, that will come under the Cinematography Act 1952. Now coming to publication or broadcast in the media. If a company resorts or such indecent representation of women, the company shall be deemed to be guilty of this offense. Section 4 of A of 1 provides exception to any book, pamphlet, paper, slide, film, writing, drawing, painting, photograph, representation of figure, publication of which is justified on the ground of science, literature, art, or learning, or other object of a general concern. There is another section, section 4 of A of 2, which is kept or used bona fide for religious purpose. The image of a naked but giving goddesses are entirely part of the Indian religious iconography. So we see that art cannot be interpreted figuratively. It cannot be stripped from its symbolic meaning. So be cautious while you are writing any thing about the women as a journalism students or journalist or a mass communication as a reporter or correspondent, whatever it is. You must be aware about this act, the Indecent Representation of Women Prohibition Act of 1986. Next, we will move to the another important topic, that is the Children's Act. In the year 1960, it is enacted in the 1960. The Children Act was passed by the Indian Parliament in December 1960 to provide for the care, protection, maintenance, welfare, training, education, trial, and rehabilitation of neglected and criminal children for the states and union territories. of the India. This act covers all over India. Before that, Jammu and Kashmir, before our absorption of the 370 article, there is a limitation. But after that one, this act is implemented to the all parts of the India. What will be, for example, we could not mention the child name. We could not show the child whether they were in a physical condition. So we see in the video clippings, there is a marking on the face of child. So this act you should be know as a journalism student. The act provides for two agencies. They are the Child Welfare Board. It deals with the neglected children, and the Children's Court for delinquent children. In case court cases, accused or even verdict released, even though if in case the person is a children, we could not name is the person name, the children name in the publication. We could not quote the name, right? In fact, the composition and functions of the both the agencies are the same as that of the juvenile court. In case, in generally we call it is a juvenile court in other parts of the world. Even though in India also we have a juvenile courts, because that is only children. Children means under the age of 18 years. As per our laws and other acts, the children age is below 18 years. Procedure of the act. The basic principle involved in this legal procedure pertaining to juvenile courts in India under the above act, as elsewhere in the advanced countries of the world, is that it should not make of criminal proceedings. Next, the procedure should be in conformity with the principles that the child should not have the stigma of criminality attached to his behavior. The juvenile court procedure should have no semblance with the procedure of a criminal court, but the social atmosphere should be that of a child guidance clinic or a parent counseling service is required. Dear students, if you have any doubts, otherwise we will go with the new topic. Coming to the important topic, that is defamation. Defamation is a communication about a person that tends to hurt the person's reputation. Defamation is a strict liability tort, which means the intentions of the defamer are not relevant. The communication must be made to other people, not just to the person it's about. The statement must be false to be classified as defamation. If it is a spoken, the defamation is the term as a slander. If it is a written, the term called libel. It can also be a gesture, which is a type of slander. Journalists are likely to commit libel as a part of their professional duty. Defamation gives rise to both criminal and civil action. Criminal law of defamation is let us discuss about the criminal law. Criminal law of defamation is exhaustively codified in a section, previous section we have mentioned in the textbook, but now after BNS, new title, earlier there is a IPC sections, now we have a Bharat Samhita, Nyaya Samhita, BNS sections, but you here just identify the context, not the numbers. Okay, there is a codified civil law of defamation. In civil cases, the courts decide the quantum of damages to be awarded depending on the merits. There is a section 499 section previously where it is defined as whoever by words either spoken or intended to be read or by signs or by visible representation makes or publishes in any imputation concerning any person intending to harm or knowing or having reason to believe that such imputation will harm. The imputation of such person is said except in cases herein after expected they defame that person. In case if a defamation, if any journalist is facing this defamation case, there is some explanations also given. If our explanation is satisfy the defamer, they may be accept it and you will be believed from that case. So explanation one, what can it may amount of defamation to impute anything to a deceased person. If the imputation would harm the reputation of that person if living and is intended to be artful to the feelings of his family or other near relatives. Next, explanation 2. It may amount to defamation to make an imputation concerning a company or an association or collection of persons such as. Next, another explanation, an imputation in the form of an alternative or expressed ironically may amount of defamation. Another explanation, no imputation is said to harm a person's reputation unless that imputation directly or indirectly in the estimation of others, lowers the moral or intellectual character of that person or lowers the character of that person in respect of his caste or of his calling or lowers the credit of that person or causes it to be believed that the body of that person is in a loathsome state or in a state generally considered as disgraceful. The law gives 10 exceptions. This law gives 10 exceptions. Also, when an imputation is not defamation. Apart from this, journalists have three more defenses. What are those? That the imputation is made for public good. Another one is in a good faith. One more is it is privileged. So these three exceptions for the journalist. Generally, we see in newspapers and television wherever the generally politicians they file the defamation act in case of any harmful statements by the journalist or publication or broadcasting in the newspaper, broadcasting in newspapers or television. When the political leader or any dignitary who says they are going to file a defamation case of such amount, 2 crores, 3 crores, like we see in the newspapers and in the televisions. So even though as a journalism students, in case of this defamation case, we may to give a explanation. Otherwise, we may, if it is meet the public good and good faith, or it is a privileged, then it should be published. It should be broadcast. The statement must be false to be classified as a defamation. If it is spoken, then defamation is termed slander. Spoken is a slander. If it is a written, it is termed libel. So there is a two types of defamation. One is a slander, another one is a libel. Now coming to discuss about the libel defamation. Libel defamation is the type of defamation with a permanent record, like a newspaper. In case it is published in the newspaper, that is a permanent record. In case it is a broadcasted in the television or broadcast in the radio, we may, in case it is a recorded one with them, we may face it. In case we may correct it in the following bulletin, in the following edition of broadcasting. So that is one little advantage for the broadcast journalism. But whether it is in the newspaper, for the newspaper journalism, journalists, they must be cautious because that is a permanent record. So a permanent record means a newspaper or a letter or even a website posting or an email, a picture, a radio or broadcast. All these, for example, in an email, it will be also permanent. We could not correct it. In case website posting, we have a choice to correct it. In case if we face, we may know immediately, we may correct it. But in the case of newspaper, it is not possible. Either we have to give again one rejoinder in the next day newspaper. Otherwise, we have to ask the sorry, like, so it is happens. So dear students, as general students, you must be aware of this libel defamation. If as a journalist, if you can prove that someone libeled you, then a court will presume that you suffered damages and award you may you money or for your damaged reputation. We notice it in the notices it in the many cases. Many politicians, they uh, very frequently use this statement. If any statement or publication against means that will attract the libel defamation, they says in a open statements about the particular amount. Next, in deciding on damages, the court will consider your position and reputation in the community. For example, if you are a professional, damages may be higher. So the court will look in all these matters. Next one is slider, slander. Sorry, slander type of a defamation. Slander is the type of defamation with no permanent record. Normally, it is a spoken statement. It can also be handgesture or something similar. The law treats slander differently from libel. With slander, you have to prove you suffered damage in the form of financial loss to get compensation. This is for the defamer, not the journalist, you be aware. But with the libel, the law presumes you suffered damages. For example, say that you sue Ravi and prove that you lost business with Ganesh because of what Ravi said. Ravi would have to pay you for the loss of business, but not for the general damage to your reputation. It can be very hard to prove this sort of financial loss. That is why most slander cases never go to the court. Yeah, dear students, we have in the syllabus some IPC sections relevant to the media. Let us discuss about these IPC sections. The penal code, the Indian penal code now it is BNS, whatever it is. The title itself changed, but the code content and the section numbers are changed. But the inner core we have to be looking here. Okay. The object of this code is to identify the offenses which are prohibited and prescribed penalties for them. Some of the offenses prohibited by this code among that amounting to misuse of a freedom of speech and expression or sedition and defamation. Here is a one section, that is a section 124 of A of the IPC. Now this changed, but be aware about the matter. Okay. This section quotes states that if any person by any words written or spoken or by making any visible signs attempt to bring the feeling of hatred or contempt against the government shall amount to sedition and will be punishable with imprisonment, fine, or both. This section places a general restraint on the freedom of speech and expression, inclusive of freedom of press. Freedom of press, there is a, in our constitution, there is a no particular article related to the freedom of press, but the freedom of press comes under the freedom of speech and expression. Freedom of press does not include the freedom of projection, the feeling of hatred or contempt towards the government. The right to reasonable criticism prevails, which does not amount to sedition. The second general restriction imposed by the court is in the form of defamation. Already we have learnt about the defamation. The common misuse of freedom of speech and expression which prevails is the offense of defamation. Right of freedom of speech and expression through press does not include the right to injure a person's reputation by making false statements or by visible representation or gesture. Right to freedom of the speech and expression through press does not include the right to define, defame even a deceased person or a company or association or likewise. Though it seems a general restriction, it is a very vital restriction imposed on the freedom of speech and expression of the press. Media personnel should know what this section, another important section, that is section number 228, which is 228 of IPC, but it is slightly changed in the new BNS, whatever it is. But the point, the core content, you have to be known it. At times, media as a whole and media personnel in general are becoming over enthusiastic in the matters concerning the identity of the victim of certain offenses. Generally, already we have learned about the Child Act, Women Act. We could not give the names in the publication in such identified offenses. Forgetting the very fact that there is a vast difference between the convicted and the accused. In the news, we must write only accused until it is proven in the court. Once convicted only, we have to mention. In Telugu newspaper, generally, here we have to be. Here I have to be give one some examples in Telugu newspapers, like don't name the name of the newspapers, but the matter. In case some cases happen, some murder is happen, where you have to be, as a journalism student, you have to be mentioned only the accused person, accused only. You could not be give the verdict. In Telugu, generally, we call నిందితుడు, not తీర్పు ఇచ్చిన తర్వాత, post the verdict, only we have to be called it is a ఖైదీ, convicted. So these points you must be reminded. Once the convicted only, we call it is a prisoner. Before only the proceedings, court proceeding is ongoing, we must call it is only accused, not the convicted or a prisoner. Right? There is some other sections also there in the IPC, but it is now changed. Be remind that now it is a BNS. Okay, all these sections also changed. You may not be to give a new sections, but this is as a journalism student, this is, you have to know the matter. What in the practice, in our field, when we are practicing journalism, we must be aware of this codes. There is some course sections is there, 376, 376 of A, 376 of B, 376C, 376B. All these sections alleged or found to have been committed shall be punished with imprisonment of either description of for a term which may extend to 2 years and shall also be liable to fine. There is a one more section is that is the 501, 502 is some sections is there. These sections prohibits the printing or engraving of defamatory matter. So also selling of such a printed or engraved defamatory substance is an offense under section 502 of Indian Penal Code. So it can be started that Indian Penal Code imposes 2 restrictions in the general from on the freedom of speech and expression through press. So as a journalism students, we must be aware of these all the sections, not exactly because the IPC is just renamed as a BNS. The titles of members of the sections members are now it has been changed, but even though we must be aware of the code content. Yeah, well, dear students, if you have any doubts, you may raise your hand and ask me if you have any doubts. I will get you back with the clarification. So far, we have learned in this unit about the contempt of court. There is again 2 types, criminal and civil. And we learned about the provision of the publication of provision on women, and one more act, that is a Children Act, and we learned about the defamation. We learned about some IPC sections. Means nowadays the renamed as a BNS. We have learned about some sections also. We'll in the next session we will go with another new topic, new lesson, that is laws relating to the rights. What kind of laws we have, rights we have. So when we have to learn about the rights, we learn about some acts related to the secrets of India. So in the next session, we will learn about the Official Secret Act and Right to Information Act, Intellectual Property Rights, Copyright Act, Right to Privacy. So here I am concluding this session. My dear students, if you have any doubts, you may ask. It is mainly the counseling session. So your interaction is much encouraged. Thank you very much for the attending this counseling class.